Hey guys, mute my channel when it starts. I hope everybody had a good lunch. I am still having mine. Um, my Herbalife protein shakes. I can have pumpkin spice year round now because this is pumpkin cheesecake. I can have pumpkin spice year round. I love it. It's so good. Their pumpkin spice latte, though, does not taste like latte. Their coffee drinks, I don't taste any coffee in them at all. That's good. And it's part of what helped me to lose the 50 pounds. So I need to start doing it again because I'm stuck. Hey, Kimmy! Hi! They are in the courtroom, but there is no sound yet. This court has been pretty good about being back when they say they're going to be back. I do have to give them that. With the last witness, oh, come on, StreamYard, that I found interesting. Come on, StreamYard. Was that he actually, in his first trial, admitted on the stand that it was a homicide when he actually believed it was an accident. Why would you do that? Knowing that you were on trial, knowing that you were on trial for murder. Okay, I'm freaking out. What is going on with StreamYard? I swear, StreamYard is going to be the death of me. Nope, it's not going to catch up. It's just going to crash. Okay. Oh my gosh. Oh, Judy, I thought you were better. I feel so bad for you. I thought the cruise was going to be fun. And instead, you came home sick. But I found that interesting that he actually, because he didn't know how to answer one of the questions, so he agreed that it was murder. Why would you do that? If you believed it was an accident, you were the person on trial, would you even on the stand continue to say it was an accident? I don't know. I didn't see the first trial. I
Please be seated.
I can't tell from this whether he did it or not. I just don't understand why he would do that. Yeah. Yeah, there was a phone call. Remember at the very end with the last witness with his sister? They were talking about a phone call that the defense that Todd's lawyers wanted to play. Remember she kept the state kept objecting to hearsay and they wouldn't let them play that phone call. That phone call was from the day of the trial where he took the stand, and there I don't know what specific question he was asked, but he agreed that it was murder on the stand. Yet the phone call that he had with his sister that same day, he said that no, it was an accident, but he didn't know how to answer the question or something to that effect. But they wouldn't let them play the phone call because it was hearsay. So that objection got sustained and they didn't get to play the phone call. Why would you do that? Why would you agree it was murder if you're on trial for that murder and you believed it was an accident? I don't understand why he would answer it that way. I would say under no circumstances would I ever say, yes, it was a murder. I would say, no, it was an accident. It was a farm accident. I would never change my story, no matter what, to, yes, it was a murder. Because then you have to say, well, it was somebody else that murdered her. I didn't do it. It was somebody else. So that doesn't, I don't understand why he would do that. That's weird. Of course, I don't understand the psychology of somebody being falsely imprisoned either. I mean, hey, Rodney, I don't know how long at that point he'd been in jail. I don't know how his head, psychologically, how it affects you to be in jail. Maybe because, look at the Delphi murders. I mean, look at Richard Allen. He was in solitary. That screwed him up big time. He confessed to doing it, and I don't think he did. Oh, okay. Yeah, something like that. This is I think it's technically a hearing. They're calling it a trial, but I think technically it's a hearing. This guy, Kimmy, in 2018, his wife was found with a corn rake in her back, and he was put on trial for murder and was convicted. And this is a post conviction relief hearing to see if he can get a new trial. Now, he said it was an accident, but they convicted him of murder. Now, the reason why they think he murdered her was because she was an RN. She was an RN and I think she worked in the emergency room. Anyway, she had an affair with someone and they went to marriage counseling and supposedly worked it all out. And she quit her job and went to work on his pig farm with him. So they had this business together. And he kept very close tabs on her after that. almost, just like very controlling. And yeah. And so then she started having an affair with one of the other workers on the farm. So that was supposedly the motive. Yeah, her son found her. He was, I think, 16 16 at the time, and they picked her up, put her in the truck, and drove. Because when you're way out in the middle of nowhere, you pick them up and take them to the hospital. I live out in the middle of nowhere. That's what you do. And then they called 911. Oh, was it 13? Was it 13 then and he's 16 now? Wait, no, that wouldn't be right. Okay, maybe it was 13. You guys know I have Swiss cheese brain. Chemo brain. So, on the way to the hospital, he called 911 and they made him stop and do CPR. And then how many ambulances responded? Like 2 or 3. And then they ended up arresting him for murder.
Okay, we'll go back on the record. Just before lunch, both parties rested in terms of calling live witnesses. However, I think at least the applicant has additional witnesses to identify by deposition. Is that correct, counsel?
Yes, Your Honor, I believe they're on the exhibit list, and the court would like, we can go through them.
Yes, let's do that, please.
Exhibit 204, Turbot 2019 deposition.
Okay.
And I believe both of these have already been submitted.
Yeah, we did some of them maybe at the beginning.
Yes.
Yeah. There's 258, Hemisath 2019 deposition.
All right, you show both 204 and 258 as having been previously admitted.
Okay. And then, Your Honor, 301 is TRM video deposition from 2019.
And that was previously admitted.
Okay. And then 316, 2024 deposition of Peggy Munson.
$316 was previously admitted.
317, deposition of Jonathan Turbot, 2023.
$317 was previously
There's
admitted.
not enough evidence.
Your Honor, is it okay if I just read a few of the next numbers to verify?
Certainly.
318 through 326 should all be depositions taken in 2023 of witnesses. I think the
There's not enough evidence in this right now for me to know either way. And I didn't watch the first one. So I want to watch the first trial now because I can't tell from this. I understand what the defense is saying, but I can't really tell. But the explanation for why there were 6 holes instead of 4, I can see how that would make sense. but I don't know if that's exactly what happened. They're saying like like 2 of the times didn't go in like deep, and she kind of, I guess, moved and they came out. So then when she fell back against it again, it was six punctures instead of just the 4. I don't know.
My notes show that it was admitted, but either way, we have no objection to that.
Okay, and that's what my notes show as well, that those would have been part of a stipulated group from, Tuesday of last week, so.
And then the last of the deposition should be 338 through 344, and I believe we've already all agreed and admitted those.
Yes, I show that those have all been admitted.
And 346, and 352 got left off that page.
I show both 346 and 352 as admitted.
And then 355,
I don't even know.
355 is admitted.
so the only one
I'm gonna have
we
to
would
Google that.
be asking to admit that the state's objecting to it this time is the deposition of Jake Firehelm from 2023, marked as 323. Applicant recognizes Mr. Firehelm did testify, but his deposition had to be utilized multiple times during his testimony to refresh him or to correct his testimony. And we think it's appropriate at this time to ask the court to admit it for the proper weight of what it was used for.
Counsel?
And the state would object to the admission of the deposition. And I would just note for clarity of the record that this was a discovery deposition. I believe it was taken before the state even had the benefit of receiving discovery. Not that there was any problem with that, given the timing of when it occurred, that was to be expected. However, given the timing, the fact that it was a discovery deposition, it, in the state's opinion, does not make sense to admit it. And as Mr. Firehelm testified in his testimony here on Friday, confirmed that he did not have his own file when he had that deposition. I believe the parties were able to adequately impeach or refresh his recollection based on his deposition, so his testimony should remain as what he gave in court.
Any further argument in support of your request to admit 323, Ms. Nichols-Cook?
Your Honor, I think our goal here is a complete record for the court to have, and it is additional sworn testimony that Mr. Firehelm gave in addition to the affidavit that he signed and was shown. And I believe the deposition will assist the court in evaluating his credibility and his testimony this week.
323 will be admitted.
Thank you, Your Honor. Your Honor, I believe the parties have an agreement as to Exhibit 371. This is a DCI Google search comparison chart created by Roman Gamble, and we would seek to admit it.
I show 371 as having been previously admitted.
I believe it was referred to during Sheriff Hemeth's testimony. However, in any event, we have no objection to it. I believe he.
Okay, obviously admitted. It will be at this point.
And Your Honor, I know in our last witness, we talked about 375, the jail call records. We would still move to admit for the court's consideration just the September 22nd, 2019 phone call recording that is within that exhibit. it might be more as an offer of proof because of the objections that were made to its admission, and ask that it be admitted as an offer of proof.
375 was
Yes.
the number? Okay.
There's many phone call recordings within that electronic exhibit, and we're just specifically asking for the September 22nd, 2019 call. I apologize, I don't have a better way of identifying it for you.
To the extent it's being, or the court's being asked to consider it as an offer of proof, any additional record you wish to make on that point, Mr. Baki?
Yes, Your Honor. The state objects to the admission of the jail call for the reasons already stated and addressed in the record, hearsay, among others. I guess I'm confused what the purpose of admitting it for an offer of proof would be at this point when no additional witness testimony is expected. So we would object to its admission.
Well, the court will consider it as an offer of proof, just so that it is part of the record for purposes of any further proceedings in this matter.
Thank you, Your Honor.
Are you going to refile that?
Just that once.
All right. And I know we have some other exhibits to talk about. Ms. Nichols-Cook, does that address all of the additional witness testimony that was coming in on behalf of the applicant through deposition?
Yes, Your Honor, there's one topic regarding Mr. Saber's position, are separate exhibits on this court's trial exhibit list. And I know the state had some objections to some of those. And I don't know if the court would like me to identify which ones I believe are referenced in Saber's deposition for the record, or what's the best way to do that?
That's probably the best way to do it if they're not all contained within the same exhibit. So Mr. Saber's deposition is which number?
320, what? 323? 325.
Okay. And then the exhibits that go with Mr. Saber's deposition.
That would start at 219, Your Honor.
Okay.
220. 223. Yes, 223, I'm sorry. 234. 235. 236. 237. 238. 239. 240. Actually, through 246. And then 247. Through 252. And 278. I believe those are all the ones referenced in that deposition.
Okay, so some of these are on my list of previously referenced exhibits that were problematic. I don't know if those are the ones that you're referring to, or if it is some of the newly identified exhibits that are troublesome, I guess. Mr. Baki or Mr. Duden, did one of the two of you wish to identify which exhibits are objected to, or do you need a minute to confer?
Are we gonna watch a deposition or what? What are they doing? I'm so confused right now.
Your Honor, our objection is only to what we had previously expressed during our pretrial motions as well. That we would ask that those exhibits and depositions be considered for their weight because they do contain hearsay, rather than more so for the truth of the matter asserted. But we would also note that 252 has been previously admitted as a part of 233. I believe it's the later pages of 233 are in the middle section. Either way, for clarity of the record, we don't have an issue because it's cumulative and the court's already admitted it. And subject to the state's objection on the use of hearsay testimony in those exhibits, we don't have any objection to those being included here.
Oh, so now hearsay is okay?
All right, so 325, the deposition of Bob Savers was previously admitted. And then as I understand it, 219, 220, 223, 234, 235, 236, 237, 238, 239, 240 through 246, 247 through 252, and 278 will also be admitted, subject to any prior orders of the court limiting those exhibits. And it's possible that at least one of those was already previously admitted, I guess.
Yes.
Okay, all right. Okay.
Okay, thank you, Your Honor. I think after that, it takes us into exhibits related to expert testimony. I believe those would be exhibit 274.
He said something about new information, but I don't think there's been new information. Like, there hasn't been a gotcha moment. Everything has just been, they've been talking about things that happened in the last trial that were done wrong or shouldn't have been said or shouldn't have been assumed. I've not heard anything that they've said, well, you didn't know this back then or something, you know? They've not highlighted any new information. So I don't know what that was supposed to mean, that there was some new information. So I don't know how they got. I mean, obviously you have to have some reason to be allowed to have this hearing. They don't just let anybody have a hearing, because if they did that, it would jam up all the courts and nothing would get done, because everybody would want to have a hearing like this. Because he already lost his appeal. So this is happening after his appeal. So there had to be some reason they gave him this post-conviction relief hearing. And I didn't hear anything that is extremely compelling as to why he needs a new trial. So I don't know.
Dr. Bowley's report. 279, Dr. Weck's report. 285, Dr. Nye's report. 276, the portion that is Dr. Hammer's report. 281. I understand the state has raised a concern that they could be improperly used to bolster or vouch the experts who did testify. However, expert witnesses are allowed to rely on other information and data under Rule 703. This is something they testified they normally do in the course of offering an expert opinion. The data in 703 is not hearsay. It's also, this is a bench trial, and again, the court can afford their proper weight to these exhibits. And it goes to more than just, what Dr. Hammers and Dr. Nye testified to. It shows the prejudice of counsel's errors at the trial, and provides that context for the court and the record of what is being discussed and reviewed. So even the reports don't have to be admitted for the truth of what they're saying, but it's for their use under 703.
Response on behalf of the state.
Yes, Your Honor. As the court knows, we have always objected to the inclusion of, especially of the reports and information present in this case from non-testifying experts. Those reports are being offered, in our opinion, either for a vouching purpose or for the truth of the matter asserted, and therefore our hearsay that would be impermissible for inclusion of the record here. But for the use of those reports, subject to the state's objection, we have no issue with the court taking it under advisement if they would like to evaluate it, given that prior discussions have occurred for.
And earlier, when it was something that he wanted in, he said, oh, it's hearsay, but it's not for the purpose, or it's not for the truth of the matter asserted, so it can stay in. Because he wanted it in. That's why I said, oh, now hearsay is okay.
For instance, of Dr. Nye's first report as a mere report of vouching to the credibility determinations of Dr. Bowley or Boley, who did not testify here. In subject to our hearsay objection, I don't think there's any way around considering them for their truth value. So we would ask that they remain to be excluded in subject to the court's determination, but no further arguments necessary on these, because we've maintained our objections from the very beginning and before we came to trial.
The expert reports will be admitted subject to those objections. And my final order will clarify, I guess, to what extent, if at all, the court considers the opinions of the experts. Well, and let me clarify. I'm going to defer my determination of admission of the expert reports and my final order will indicate to you what is admitted. Because I do need to review those in more detail to determine if I can separate out any portion of the report that should not be admitted. And primarily that deals with the information from Boley. Under the case law and under the rule, it really is the Boley report that is problematic. I don't think that there is any way of interpreting the inclusion of Boley's report in Dr. Nye's report, for example, as anything other than a conduit for getting Boley's opinion in when it otherwise wouldn't come in. And that is not permissible under our rules and under our case law. And so I think it can be excised in all likelihood without damaging or taking away that portion of the work that Dr. Nye did, certainly from her second report. But I will clarify for the parties in a written ruling that in fact that is what I have done. And so with regard to the experts, that will be the plan that we follow with those reports.
Can I get clarity on just which exhibit numbers? I was a little slow in writing them down. I apologize.
Sure. So Boley, I believe, is her separate report is identified as 274. Let me just double check my numbers here. Yeah, 274. WEC is 279. Nye is 285. Hammers is 276. And Safaric is 281.
And then, Your Honor, my friends in appeals would be remiss if I didn't ask to do this. But regarding the jail call that was submitted for the offer of proof, if I can read the name of that file into the record, just so everyone is clear going forward what we were talking about, if there's no objection.
Go ahead.
My records show it is called 687-308-34 underscore 392804 underscore 09-22-2019 underscore 08-12-58. And there's more to it, but I believe that should be sufficient to identify.
Thank you for that. I'm sure that'll be helpful for the court too in locating the particular call to the extent I would need to. So. Okay. Ms. Nichols-Cook, anything else that you wish to address with regard to exhibits?
Your Honor, I know that we all agree the underlying record is a part of this proceeding. I think we've realized we did not file the motion for new trial sentencing transcript from September 4th.
Yeah, I said, why are they giggling?
And we would like that to be a part, of course, of the record.
Just a number.
If there's no objection, we can upload that today. And it would be like 978, I think.
Any objection to that, council?
No, Your Honor, it's already part of the record. If it's easier to have it filed here, no objection.
It doesn't make any difference to me. I mean, if you wish to have it marked as a separate exhibit in this file, that's fine. But certainly by statute, the underlying case file would be considered part of this record. So it's up to you, council, if you wish to have it marked separately.
I think so, Your Honor.
Okay.
Just for clarity, what's 977?
An email that a fire home was shown. Right? Cool.
So it's not, but it was just no purpose. Perfect.
Right, so 978 was the number you said you would use for that? Okay, that will be admitted.
Your Honor, the next thing on my list is to address the photographs that were submitted as exhibits. Obviously, we did not show or utilize every photograph that had been proposed. And I think that we can identify a handful of them that we know were shown to witnesses that we believe should be a part of the record, but we also don't oppose the admission of additional photographs or the group exhibit in its entirety, if that's what the court would like.
So I show, for example, 500 through 580 as having been admitted, which I believe are all photos. And I know that we didn't, or the witness didn't talk specifically about all of those, but I do show that they've been admitted. Also 600 through 655, which I believe are all photos. And again, I know they weren't all specifically referenced, but I do show that they were admitted.
I believe 700 through 734 are DCI photographs. We would have no objection to those. I believe only 731 has been admitted thus far, but for what it's worth, we would not object to the 700 series.
Okay. Did you wish to offer those then at this time?
We would offer those then.
All right, so 700 through 734 will be admitted. I know, I think there are probably some other photos sprinkled in through there, but those are the big groups that catch my eye.
Your Honor, I had 3 in the 900 series that related to Dr. Nye's testimony, and I'm happy to just identify those 3 for the record if that works.
I show 929 and 938 as being admitted.
Okay.
976, I think we were arguing about.
And I think for clarity, the photos are 800 through 975. So the third one that I have down is 890.
And I show 890 as being admitted.
And we're not seeking the admission of the rest of the Dr. Nye photos. fine with council, we would move to admit Exhibit 976 related to Dr. Nye's additional records, with, the understanding that these would be for the courts, to assist the court in understanding the testimony and as additional offers of proof, if not directly admissible on their own.
Any response, counsel?
Yes, Your Honor. The state has, conveyed fundamental issues with the 14-page supplemental information that was included with Dr. Nye's testimony. Certainly, I think the parts that are worked with or were worked with during her testimony fall on pages 12 and 14. 12 being her calculation page that was referred to, and 14 being the citation page or references page. The state has no issue with the admission of pages 12 and 14. The rest is a little bit wonky, given that it is aspects or portions of other admitted exhibits, not Dr. Nye's work, but kind of like a drop document that was used for things that she'd want to refer to later. So we would object based upon hearsay in the inclusion specifically, as it wasn't in her expert reports, but would simply ask that the court accept the 14-page document subject to the state's objection and reserve ruling on it like the other expert report information specifically, given that it also includes portions of other experts' reports like Dr. Hammers, Dr. Bully, and other outlier information or demonstratives.
Right, 976 then will be treated in the same fashion as the, I guess, the substantive expert reports will be. Any additional exhibit issues to address on behalf of the applicant?
Your Honor, we are waiting a signed stipulation declaration regarding exhibits 390 through 396. There'll be two declarations from court administration that to authenticate and lay the foundation for those exhibits. We would ask to be allowed to move those in upon receipt of those declarations.
Any objection to that on behalf of the state?
We don't know what the full declarations look like, so we would ask that the court allow us to defer. We don't anticipate there being any issue with the declarations, but some of the information was still kind of outstanding or highlighted within the judicial branch's declaration page.
Okay, I guess on that issue then we technically probably just need to leave the room open to receive those.
Your Honor, we just received the signed one, so maybe if we circle back to this in 5 minutes.
Certainly,
sure we can
that
resolve
works just fine. We'll do that.
Your Honor, I just had a couple left on my list to make a formal record on, that the applicant does seek to admit the affidavit of Carrie Piercebacher as identified as Exhibit 215, the affidavit of Jake Firehelm in 224, the affidavit of Donald Potabom in 379, as well as a transcript of the November 10th, 2018 911 call identified as Exhibit 294.
Response on behalf of the state.
To the extent, I do apologize that I was looking at the portions for the declarations. If my understanding is we're asked about the affidavits specifically.
Yes, of Carrie Pierschbacher, Gerald Firehelm,
Mr. Potabom.
and then the transcript from the 911 call.
Yes, Your Honor, we would renew our objections to the admission of affidavits. I believe on Monday, the court made clear on the record first with regard to Carrie Pierschbacher, that affidavits wouldn't be admitted for the testimonial purposes that they've been sought for. Especially for Mr. Potabom, for instance, we believe that testimony would be uncrossed and relatively inadmissible or misleading for the court, so it would be objected to on those grounds. We believe each one constitutes hearsay, and we already addressed, I believe, Ms. Pierschbacher's affidavit, but we did allow, without objection, the admission of her report. So her affidavit was unnecessary, but we would renew our objections to the remainder of the affidavits. As for the transcript of the 911 call, our position is, as we've said previously, we object to it on a hearsay ground, specifically that the record speaks for itself. The 911 call was subject to the Court of Appeals opinion. It was subject to being played in the underlying case for the trial, and certainly the court has engaged in some portions or prior rulings in the summary judgment phase or summary disposition phase here as it relates to those 911 calls and potential enhancements. Should the court wish to receive the certified transcript, not for its truth value, but to assist or clarify the testimony of, say, Mr. Firehelm, for instance, we have no issue with the court receiving that subject to our objection and that it wouldn't be considered for its truth of the matter asserted.
The three affidavits that are being offered will not be admitted. Exhibit 294, I believe, is the 911 transcript. Will be admitted.
I believe that is all I have, Your Honor. And then we do have a list going of demonstrative exhibits that we identified during testimony. And we would like perhaps a little time to provide that to counsel and then present them.
Yes, I guess there was a question between the parties, the best way to file those. In past cases I've seen where the court files them as court exhibits. On that, we don't have to make a complete record. Our friends on the appellate side will appreciate the clarity.
Yeah, I do think they need to be made a part of the record, but it is important to distinguish them from the actual exhibits. And so I'm fine calling them court exhibits or demonstratives, just so that we're careful to keep them separate. They were all, I guess, paper, which helps. But if you would like to gather those up, and you can provide them to me if you'd like before we leave here today, and I can make sure that they get into the record. That's fine.
Thank you, Your Honor.
For purposes of closings, given that the demonstratives have been referred to fairly repeatedly as the same letters that cross over with the state's exhibits, referring to them as demonstrative D or whatever would be probably the easiest way of going forward. Is that okay with the court as well?
It is, yes.
Thank you. And we'll refer to ours for purposes of the record too, with the court's permission, I think making a good record here is probably the easiest part. We refer to our exhibits as exhibits A, B, C, D, F, G, H, and I believe. But we did not admit exhibit E, and we have filed them as PCR-A, et cetera, simply because the underlying record, the other ones were unavailable. So we would ask that the court recognize or accept that while we may speak to our exhibits or the exhibits that have been admitted here as A, B, C, et cetera, that those exhibits be understood to mean PCR-A or B, et cetera.
Certainly. And I did note that in the electronic record and understood the correlation and the reason why they were labeled that way.
Sure. Thank you, Your Honor.
Anything else as far as exhibits or clarifications for the record on behalf of the applicant? Sure.
Your Honor, we have executed a stipulation that the state will file here in a moment regarding Amy Burnell. And I think Your Honor, can I verify that Exhibit 314 medical records, which I don't believe was an objection to, was admitted?
I do not show 314 as having been admitted.
I'd likewise not show it as admitted. I don't believe we have an objection to them, especially considering that we stipulated on Dr. Thompson's deposition and files. However, given that it is medical information and has unredacted information as would be expected, we would ask for that to be at a heightened security level. I believe a level 1 would be adequate.
Okay. 314 will be admitted.
I don't believe I have anything else, Your Honor.
Your Honor, I'll ask it this way. And I believe there was some question about security levels on a few of the exhibits. I believe most of the problematic ones weren't offered, so it should be minimal. But I don't know if maybe additional time before they're formally admitted, if the parties can, or if Mr. Mullis's counsel already knows if there's any additional ones that might need a heightened security level.
So other than 314 that we just talked about, I can tell you that the only other one that I have a note on right now as needing a higher security level is 400.
Your Honor, I think the applicant would have no objection to any of the medical examiner photos being filed at a high security level, or Dr. Thompson's photo collection.
We have no objection with that. The 500 and 600 series photos. I do note, for whatever reason, it appears that they might not have been filed at a heightened security level in the underlying case. It's my opinion that had to have been an oversight. I don't know if that's something we can also resolve while the parties are all here. But
I think that if everyone is in agreement, I can probably address that.
Your Honor, the applicant would have no objection to increasing the security level of the photos in the criminal case. I think additionally, there's a couple of photos in the 200s that were used in depositions that have been admitted that would also require a higher security level, and perhaps the autopsy report. So like 225 through 229.
as well as the state's Exhibit B, which is an autopsy report as well.
Okay, I've got notes on those. The security exhibit management order, I believe that direct additions or correction, identify any additional changes that should be made with regard to not only the exhibits that are identified as having been admitted, but also the security levels that are established. Certainly feel free to bring that to the court's attention so that changes can be made. I know that it's easier for clerk staff and certainly less work if it can be done up front rather than later on. So,
And I do, just as I was scrolling through this list, I do recognize there's probably going to be additional, such as 216, the EMT report has a date of birth. So maybe, so we do this once, if the court would be willing to defer filing of the exhibit order so the parties have time to go through the exhibits just to identify any confidential material or attempt to.
that's certainly fine, counsel. If you'd like to confer and send me an email within the next day or two, we can wait to file that. That's not a problem at all.
Thank you.
In Your Honor, I can confirm that the stipulation filing reached between the parties has been electronically signed, but also filed for the court's review and agreement here regarding Miss Amy Burnow's testimony.
All right, thank you. And then, I guess maybe so I don't forget, I'll come back to the declaration and exhibits from court administration. I think that was 390 through 396. Has everybody had a chance to look at that, or do we need a little more time on that one?
I believe the 390 through 396 portions for the jury management questionnaires or jury-related information has already been redacted and provided. And the state has no dispute about the admission or foundation of that testimony or those exhibits being admitted here.
Okay. So the 390 through 396 will be admitted if I don't think they were previously.
Your Honor, I'm sorry, there was one more related to the jury discussion. It's Exhibit 397. It's a U.S. Census Bureau report. We would ask the court to take judicial notice of that exhibit.
Any objection to that, counsel?
Your Honor, I don't think we have any issue with the information in that exhibit being accepted as census information or anything like that. To the extent that the court wants to take judicial notice of that information, then we have no dispute or really any issue with it being admitted as census information.
Well, yeah, and I guess I understand the request to be that I would take judicial notice of it rather than admit it as an exhibit. So I'll notice it. So,
Thank you, Your Honor.
yep. I'll jump over to the state maybe for now. Any witness stipulations, exhibit issues on behalf of the state? I have not necessarily cross-referenced my list of notes as far as outstanding exhibit issues. Maybe for fear we'll discover more, but I think we've hit certainly the major things as far as exhibit reports.
I guess the only clarification, just to make sure that your list matches ours, that it's all except Exhibit E has been admitted. Then I believe we have covered everything as far as my notes reflected.
Have the parties compared notes as far as which exhibits of the applicants they think have been admitted?
No.
But we can do so when we verify our final list and information. We can either do it now, Your Honor, or we can do it at the time we do the protected information, but probably for purposes of closing, it might be easier just to do our closings and then verify that information after the fact, given the numerical changes and things like that.
I mean, it seems to me like it would be prudent just to be 100% certain that everybody's on the same page as far as what exhibits have been admitted before we leave here. I understand it's tedious and not super exciting to sit here and do that on the record, so we definitely don't need to do that, but maybe before you leave here today. And also just to make sure that my list appears to match as well would be a good idea, because obviously there are a lot of exhibits in this case. But with that said, if you think that we have addressed all of the kind of lingering cleanup issues that we needed to, if you would like maybe a short break before closings, we could do that and then come back and wrap up.
Yes, Your Honor, the last thing I had to put on the record was that the court's order regarding summary judgment, any motion to reconsider or enlarge would be due this Friday, and the applicant would just request an extension to consider that.
The state's position.
If I recall correctly, the summary order regarding the court's positions on summary judgment said a longer order was forthcoming. Should the court be open to it, as well as applicants' counsel, I believe that the state would just request the opportunity for that deadline to toll until after the court's full ruling speaks to it, so that the actual questions and issues can be responded to specifically in addressing the court's specific decisions.
Yeah. I kind of like that idea. That maybe seems to me to be the most efficient use of everybody's time. Counsel for the applicant, does that
No
work for you
objection to
guys?
that plan, Your Honor.
Okay. So we'll plan on that approach, and just to have less dates to keep track of, maybe, if nothing else. So, okay. All right.
And then one last matter, I believe the court indicated brief deadlines would be addressed. Do you want to do that now or at the end?
We can talk about that now. Do either of you have a request as far as how long you would like to submit final legal authority to the court? I think I mentioned earlier, I'm not contemplating anything extensive. And really, unless you're telling me you are wanting something more substantial, I'm contemplating a one-shot 5-page limit focusing on legal authority that you believe is on point and controlling, and any particular testimony or evidence from the depositions that wasn't on the record these last few days, because I do have extensive notes from the testimony that we've been listening to. So if there's something that you want to draw my attention to from those depositions, obviously I will read them, but if there's something that you want to highlight, you could do that within that 5-page limit. Yeah, go ahead.
It's my understanding from what the court indicated previously that the court would consider a legal briefing on these issues that we already laid out in our summary.
Absolutely, right, which is part of my rationale in suggesting a very limited final brief. Both parties have spent a significant amount of time already briefing the legal issues in this matter. All of that is in the court file. I have access to it. I've reviewed it, familiar with it. And so I don't know that rehashing all of it again is useful for anybody or a good use of your time at this point. So certainly to highlight the most critical pieces now that you know how the evidence has come in is fine. But to go much further than that, I don't think is particularly helpful. So,
Your Honor, at this point, I think my proposal, unfortunately, would be to ask for 30 days, in part because part of our team is out of the country later this month. And I just, to make sure that we could get all of our thoughts together and complete that. I know 5 pages isn't that much, but.
April 4th is a Friday. Otherwise, March 31st would be exactly 4 weeks from today.
I think we could probably.
Your Honor, there is a major conference that I think a number of people on applicant's side are attending, that the first day of which is April 4th. And I have some professional responsibilities at that conference. I can't move, unfortunately. I don't know if it'd be possible to make this due the 8th instead.
The 8th of April.
Yes.
Yeah, okay. Does that date work for this state?
Is the court seeking simultaneously filed?
Yes, yep, just a one.
Yes, I feel that. Yes, the deadline works wonderfully.
Okay. So April 8th, 2025 by 4:30 p.m. Okay, if we plan on coming back at 3 o'clock for final arguments, 15 minutes, and a final 5-minute rebuttal.
Thank you, Your Honor.
Okay, I'll see you then.
Checks. We can do that quick. I can make it really quick.
sunflower seeds in my teeth. Thank goodness this thing's almost over. I wonder when we'll know anything though. Because it sounds like it's going to be at least a month or more. I thought they were going to actually show video of depositions. I don't know what they just did. That was boring. It was really boring. I'm interested to hear closing, so. I don't even remember openings. Did they do openings? Man, that was just last week. It seems forever ago. Spike, you just went outside. There's no way you're done already. Anybody want a beagle? So I'm glad that this is done because I was getting a little freaked out thinking, oh no, I'm going to have to juggle this and Karen Reed again. Because Karen has hearings tomorrow and the next day. Tomorrow's Tuesday, right? So Tuesday, Wednesday, and Friday. And then I don't know what we're going to do the next week. And then the week after that, she has hearings on Tuesday and Wednesday. And Tuesday, I have a doctor's appointment in the afternoon. I never know what trial is coming up until it just comes up, except with Karen Reed, because I've been watching that one like a hawk. Does anybody know of any trials coming up that you're interested in? I don't see anything. Why is all this food on my feed? What in the heck? Oh, I saw a video on here today of somebody popping popcorn with sausage. Have you guys ever had popcorn pop with sausage before? That sounds disgusting to me. We want sausage flavored popcorn. Well, maybe I could find a trial if I could get past the food on my feed. I don't know. I don't know why there's so much food on my feed. There is a trial. Oh, nasty. That's a big fish. There's a trial. Something about it's high school students. That's what I'm trying to find. I cannot find it. Because all I can find is food. I think it's only on like day 2 or 3. I was going to say we can try to get caught up with that one. But we might not, I mean, we have Kieran Reed tomorrow and the next day, so we probably wouldn't be able to do that anyway. Seriously, every other video is food. Maybe this is how I lost all this weight. I just look at food now instead of eating it. I don't know why. I never realized how much food gets in my YouTube feed. Dang, Debbie. Good. I'm embarrassing myself now. I swear. Oh my God. It's like food, 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 dog. Food, 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 dog. You'd think there'd be something law related stuck in there somewhere. Oh, there's beagles. I'm not talking about you, Belle. I'm talking about the beagles on YouTube. You hear them? Bill's trying to figure out where it's coming from. Where were they? Where are the beagles? Oh, Shadow snuck up behind her and scared her. She's trying to figure out where the beagles are coming from. They're in here. The beagles are in here. They sound like you, huh? Come here. No, you can't get on the keyboard. You know what happens when you get on the keyboard? You push the wrong button and it all goes away. Yes, can I help you? Say hi. Say hi. Say hi. Don't. You gotta go potty, Val? What do you want, baby? What? Why are you staring at me? What? Now she's ignoring me. Okay, I'm gonna go let Belle out. I will be right back. Come on, Belle. Come on. Come on, Belle. Belle. You don't have to go? You don't have to go potty? Come on. You have a potty? What? You're still looking for the beagles? What? You have a potty? You don't have to go. You have to go? Come on. No? What? Make up your mind. Come on, baby. Come on. I don't know what you want. Well, she doesn't know what she wants to do. She'll wait until I don't have time to do it, and then she'll decide she wants something. This is going to aggravate me now because I want to find that trial. Oh, there it is. Senior trip strangulation. Oh, it's a plea agreement. It's not a trial. Oh, well, then that's boring. Never mind. Well, well, Thursday, I can take the dogs to the vet and get their nails trimmed because it's past due and they need it done really bad. So we can do Karen Reed tomorrow and the next day and Friday, and then Thursday I can take them to the vet. And then next week we'll have to find something else to watch. Or if there's no trial, no live trial going on, we can just extend the Phil Spector trial that I do in the morning and do it all day. Not all day, but longer than just an hour or two in the morning. This morning we only did a half an hour because I start after Court Vibes gets done with OJ, and she was running late this morning. I gotta watch OJ. We're waiting for Mark Furman because Kathy has not watched. Kathy is Court Vibes. She has not watched this trial, so she doesn't know about the Mark Furman stuff. And I'm watching more for her reaction to stuff than actually to watch the trial because I know stuff. I watch bits and pieces of it, and then I watch documentaries about it and reenactments of it, dramatizations of it, whatever they call it. And so we were just talking about in general about things like, why he wasn't found guilty and the glove and all that kind of stuff. And, asking questions about why was the glove found where it was found. And I was like, because of Furman. And she said she didn't know anything about Furman. I was like, you don't know about Furman? And she was like, no. And I was like, oh my God. It's like, just wait. So I think we're towards the end of February, and Furman didn't testify until March. So, but I can't wait to see Kathy's reaction to, because that is, I can't remember if I actually watched that during the trial or if I just saw it like in a documentary about the trial. But I definitely remember hearing that tape that they used to impeach him about whether or not he was racist and if he'd ever used racial slurs. Because I remember hearing that tape. I don't think so. I think this is it. It said, I must have read it on Law and Crime's website that he had 40 witnesses. That wasn't 40 witnesses. That's also where I read it that they had new information. But I didn't hear any new information either. But there's always wrong information about trials. And I don't think that's anyone's fault. I think that's just the nature of trials. Because I think people have good intentions at the beginning of trials, like this is what they want to happen, and then stuff happens and it doesn't come out the way they want it to. Except the new information thing, you would think that would be right. Because how did they get this hearing? They had to have a good reason to be allowed to have this hearing. I don't see a good reason. The only thing is maybe the explanation that she fell on it and two of the times didn't go deep in, and then she moved somehow to try to get it out of her or off of her or something, and then fell back and they went back in a different spot. But her jacket only had 4 holes. Oh, I guess that's still possible. They could have gone in the same holes in the jacket, but gone in different holes in her body. Maybe that was the new information. Maybe that's why what was she? Biomechanical engineer? Is that what Valentina Nye, whatever her name was she like biomechanical engineer or whatever? Maybe that was the new evidence. I can see where that would be plausible. I need a reenactment. I need the Mythbusters. I need the Mythbusters to do a reenactment and show me how this could have been an accident. That's what I need. And I read an article because when whoever asked me if it was first or second degree, and I looked it up, the article that I read said he'd been trying to figure out ways to do it for years, and he waited until she had a medical procedure that would cause her weak and dizzy. Let me tell y'all something about the medical procedure that she had. And I apologize if this grosses anybody out. She had a uterine ablation. They do that for women who have, some people have continuous periods, some just have super heavy periods. In other words, they stay anemic, they have severe blood loss. They go in, they do a DNC and clean everything out, and then they burn your uterus so it never bleeds again. She would have been weak and dizzy anytime before that because of the blood loss. I've had that same thing done. No, it doesn't hurt at all, actually. Doesn't hurt at all. It just makes you never bleed again because it burns the lining of your uterus. It's burnt with radio waves. You don't feel anything.
Please be seated.
So he could have done that at any time and said she fell because she's always anemic and always dizzy and lightheaded because of her blood loss. He didn't have to wait until she had that procedure.
Okay, we'll go back on the record.
I'm just
Ms.
saying, I don't
Thompson,
know.
you ready to proceed?
Thank you, Your Honor.
Your Honor, Todd Mullis has spoken the truth in this case from day one. He said this was an accident. He asked his attorneys to investigate it as an accident. He gave multiple consistent interviews. He testified at trial. He testified at child guardianship proceedings that are part of the record below from his motion for a new trial. He filed this PCR, a verified PCR. He provided affidavits. His belief has been consistent and has never wavered that this is an accident, that he was in no way involved, and that he wanted his counsel to pursue that issue for him. That's different. Changed over time. There's nothing that Todd Mullis could have said to this court that he hasn't said before. And that's why this post-conviction hearing has been about all of the evidence that should have been presented at trial to support what he's been saying all along. The court has pointed out that this is an evidentiary hearing, that all of the evidence this court is going to consider is not evidence this court heard in court during the last 6 days. Because as we just went through, the court will have depositions, the court will have documentary evidence, the court will have other evidence from the underlying record that wasn't part of what the court heard, specifically in testimony and at this hearing. But all of that together demonstrates that Todd Mullis's trial was fundamentally unfair, that the system broke down, that he did not receive the fair trial that he deserves. And that is the outcome that Mr. Mullis is asking this court to assist with now. This court really can't think about what Mr. Mullis's claims mean without thinking about what it is that actually happened at his trial. What happened at his trial was that everyone, his own counsel, the state, told this jury that Ms. Mullis's death was a murder. His own counsel agreed in opening statements that Ms. Mullis was murdered, and that belief was allowed to be presented to the jury with zero adversarial testing. I mean, this was the quote-unquote strategy that his counsel pursued at trial. Their strategy was, we're going to concede it's a murder. That's a strategy they reached on the fly, which we'll talk about in a second. And as Mr. Firehelm told this court when he testified here, Todd's going to explain it. Todd will explain all of the evidence, and that is the way that they provided counsel to him through this trial. Their strategy was Todd is going to explain the text messages. Todd is going to explain whether he knew about Ms. Mullis's affair with Mr. Frazier. Todd is going to explain the Google searches. Todd is going to explain the state of his marriage. Todd is going to explain what was happening in this argument between his wife and his mother. Todd's going to explain these hearsay statements from these witnesses. Todd is going to explain without any notice or understanding that he even needed to prepare to think about or testify about this 911 call and what he said and who was there and what he was thinking when he was frantically providing aid to his wife as she was dying. Todd's going to explain the state's circumstantial evidence that is meant to show that he was guilty. And that in effect became a trial where counsel is telling the jury, even though I told you in opening statements that Todd was wrong, believe him that he's not guilty. That is not a reasonable strategy. It's simply not a reasonable strategy. And it and all of the errors that combined cumulatively to deny him a fair trial, denied him a fair trial. There are two Sixth Amendment claims that Mr. Mullis has in this case, and they're different. We talked about these at summary judgment, but I want to talk briefly about them now. One is the Sixth Amendment claim that Todd has the right to be the master of his own defense. And we spent a lot of time on that claim at this hearing, hearing from various witnesses. And I know the court has the law on this that we provided at summary judgment. The law is that Mr. Mullis has to explicitly consent in opening statements, or has to explicitly consent to his counsel conceding his guilt in the trial. He has to explicitly consent if that's the strategy. And from all of the testimony the court heard, from Mr. Firehelm, from Mr. Sabers' deposition that the court will read, from all of Todd's letters and his testimony at the child guardianship proceedings that are in the record, that simply never happened. Todd, this resulted in a situation where his trial counsel conceded his guilt. Conceded his guilt because he told the jury that Amy Mullis was murdered. The evidence is undisputed that Todd Mullis didn't know his counsel was going to do that. The court has Mr. Sabers' deposition, who testified at a deposition, and the court can review this, that he was surprised at opening statements. He was surprised to hear that that was the position the defense was going to take, that Mr. Mullis was surprised. The court has all of his letters. The court has heard from Lynn White. The court will be able to review Todd's testimony in these child custody proceedings. Todd said he never gave counsel permission to do that. All of his letters support that that's not what he understood the strategy was going to be. Mr. Sabers didn't know that was going to be the strategy. That happened without his permission. And we explained already why that's important, because if that happened without his permission, then this isn't a matter of prejudice. It's not a matter of establishing what the outcome would have been if counsel followed a different strategy. That is just a Sixth Amendment violation, period. That really ends the analysis. And on that basis alone, Mr. Mullis receives a new trial. But that's not the only aspect of Sixth Amendment. That's not the only aspect of a Sixth Amendment violation that is present here. We have a more typical ineffective assistance of counsel claim too. And this is very important because in this case, there is no reason, and the court heard no reason from Mr. Firehelm, there is no reason in Mr. Sabers' deposition to explain why it would have been reasonable for trial counsel not to investigate and present evidence that corroborated everything that Mr. Mullis testified to at trial. To investigate and present evidence about medicine, about the electronic evidence, about these Google searches that we've been talking about text messages, about the cameras. There is no reasonable strategy that would have allowed counsel to not pursue any of this evidence, and instead to pursue what they did at trial, which is to concede this was a murder and to let Todd explain himself unaided to the jury. What's important about this, and what we want to make sure the court understands, is that even though in this evidentiary hearing, the applicant has spent a lot of time presenting evidence to the court and proving to the court that Mr. Mullis didn't agree with counsel's strategy, even if Todd Mullis never wrote a single letter to his lawyer, even if he was maybe a person with a little less understanding about the way that biomechanics work, his instincts about what might be true, even if we had none of these letters, even if we didn't have the vast record we have here that Mr. Mullis was asking about these issues, that he wanted this to be investigated, that he was seeking investigation, that he consistently and unwaveringly believed that his wife's death was an accident, even if none of that was true, and Todd Mullis had just said to his lawyers, give me the best defense you can, I don't know what happened, but do your best. If that's all he ever said, counsel would have still been ineffective. It is not Todd Mullis's job to have told counsel what the right strategy was here. As it so happens, he did. But even if he didn't, it doesn't matter, because there's no reason not to investigate these issues. This is not dependent on what Todd Mullis agreed to or not. It is ineffective for counsel to have chosen the path that they chose. And that is because they chose it without a reasonable investigation. We cited law to the court in our summary judgment briefings, and we will cite more law. The United States versus Hinton, the United States Supreme Court has said that it is ineffective for counsel not to understand science and not to get experts in a case where expertise is required. And Your Honor, this is such a case. This was clearly a medical case. Mr. Firehelm told you, I relied on my own understanding about this. You know, I was first chair, I made these decisions. I relied on my own understanding to decide that there wasn't anything I needed to pursue there. Under Hinton, under the other law that we've cited to the court and that we will cite, that's ineffective. The state may point out when it speaks to the court that in his deposition, Mr. Sabers did describe, you know, as the second chair, as the person who was not making decisions in this case, some of the things that he tried to do, because he did try to do more than Mr. Firehelm did. For instance, he himself went to the shed. He looked at these augers and he talked about that in his deposition. He also read the case materials like Mr. Firehelm did. But there's no evidence that Mr. Sabers discussed these issues with Mr. Firehelm, other than telling him that he'd visited the shed and looked at these augers. And there's no evidence that Mr. Firehelm did anything that Mr. Sabers asked him to do. The state's own exhibits show this, that there is a email from Mr. Sabers to Mr. Firehelm where they discuss, we probably should get an expert. I mean, they knew that Todd was asking them to do that. They agreed they probably should get an expert, and that just didn't happen here. They never provided case materials to an expert, either a pathologist or a biomechanical expert, who could explain to them that there was a defense here, a reasonable defense that they should have followed. They just didn't do that. And Mr. Sabers, doing his best to look at a couple of things, to give advice to Mr. Firehelm that he never followed, that's not a strategy, that's not a decision, that's failing to do what you know you should do. And there's no reason that the state is going to be able to articulate for not following the only reasonable strategy here. That leaves us with the question of what this trial would have been, the prejudice issue of Strickland, if Todd Mullis hadn't been standing alone at his trial without any of the assistance that his counsel was supposed to provide him. If his lawyer wasn't just saying, you know, trust Todd, what would the jury have heard? And at the end of this hearing, especially hearing the evidence the court's heard here in court, considering the other materials as well, the court knows the answer to that. The court knows that if this had been a fair trial with effective assistance, this jury would have heard that this was not a murder. And it would have heard that from sources that are far more credible than the state's witness who testified at trial without any cross-examination, save one question, that this was a murder. This was a medical case. And the court heard extensively, and I know we spent a lot of the court's time making sure that the court could hear the opinions of Dr. Cruz, the opinions of Dr. Hammers, the opinions of Dr. Nye, to decide what the true state of the medicine is. And based on that testimony, there's really no question what the state of the medicine is. This is not a murder. This is not a homicide. This is an accident. Dr. Hammers was able to talk about that from a pathology perspective and explain why, despite there being unopposed testimony offered at trial that Ms. Mullis had defensive wounds, that there was nothing about the state of her body or this autopsy that indicated that she was the victim of a homicide, but that this was an accident from a pathology perspective. The court knows that Dr. Cruz said that she couldn't really figure out how this happened. She just couldn't see any reason that it was an accident. And that is essentially why she determined this was a murder. After, 2 to 3 hours of doing this autopsy with other autopsies, she came to that decision, she stuck with it, and she made that decision without the benefit of any biomechanical testimony, any biomechanical advice or assistance. The court has that assistance now from Dr. Nye. Dr. Nye started looking at this case to review the opinions of others. And we're not asking the court to even consider that piece of what she did, because she then went on to do her own investigation. She did her own visit to this scene. She did her own consideration of the wound pattern. She did her own force calculations. The court has her math on her notes where she went through and actually figured this out, figured out the force that would have been required to fall from a standing height, from a kneeling height, figured out the force that would have been required and the direction of the force that would have been required for this to have happened in different ways. And from that biomechanical evaluation, she told the court that the only hypothesis that she can't disprove is that this was an accident. And there is no other biomechanical evidence before this court. If the state wanted to call a biomechanical engineer or really any witness to say that Dr. Nye was wrong, they could have done that. That's not what they did. Dr. Nye testified without any opposition. Dr. Cruz said, I really can't speak to those issues. And that's testimony that the court has to consider in deciding what the state of the evidence is here. I'll go through the other evidence the court heard briefly, because the medical evidence is the most important. The court heard that despite at trial, the unrebutted testimony, save from Mr. Mullis, was that all these searches were from the iPad and that they were very nefarious. And when the court actually gets a chance to see that those searches didn't come from the iPad, that many of them came from other devices, and the actual content of the search, that these searches are related to hunting tests, they're related to television programs. The actual content of the searches and the evidence that they didn't come from the iPad tells you that Todd's testimony was right. The court will have a chance to look at all of these texts and emails, which are in evidence, and the court heard from Mr. Safaric and others about what all of this electronic evidence means. And it proves what Todd said, which is that even though his wife was having an affair, this had not bled over into the marriage, that he didn't know about it, that they were living relatively happily, despite the fact that there were sometimes, disputes with a mother-in-law. None of this was creating this situation that resulted in some planning to end someone's wife's life. I mean, there are text messages with Todd right up until the end of Miss Mullis's life where she's saying, "I love you." The court has Tristan's testimony, and it should evaluate it, that Tristan has explained why he testified as he did and that his dad was really only out of his sight for a short time. The court knows about the 911 call. It heard a lot about that, about the discovery violation that occurred there, and that this was a trial by ambush with respect to this 911 call, and that 911 call is not what the state described, and that Todd was with other people, sheriffs, when that happened. There's a lot of other claims that counsel presented, and the court knows what the evidence about that is. Based on the evidence the court has, it knows that Todd's established his Sixth Amendment claims. It knows he's established an actual innocence claim, and that this is the rare case where, considering these claims separately or cumulatively, that a new trial is really the only fair outcome. I'm going to come back and talk in rebuttal in a minute, but based on what the court's heard, there's no doubt that Mr. Mullis's trial was unfair, and there's just one result from that, Your Honor, which is a new trial.
Thank you, Ms. Thompson.
What's the deal with the 911 call?
Closing argument on behalf of the state.
Thank you, Your Honor. May it please the court. Good afternoon. I will be brief. The state submits that Mr. Mullis has not met his burden of proof on any of his claims. We ask the court to deny his application in its entirety. In addition to the record and issues that have already been developed at trial and before it in this proceeding, we will address our legal reasoning for why each of his claims fail in our written brief. Thank you.
Counsel. Your final rebuttal.
I just want to add one more thing, which is that although we believe that we've established Mr. Mullis's actual innocence, which means that there should not be any new trial, if the state concludes that they want to rely on Dr. Cruz and retry him, that's an opportunity that he should have an opportunity to present this evidence to the jury. Because the last thing I'll say about this is the court may conclude, in looking at all of the evidence, both what it heard here, what it reads in the record, and it may determine, well, I see some evidence on the other side. I see some evidence still that for me, I don't know what to make of that. I see that the state made some arguments at the original trial, and for me, I don't know where I end up on actual innocence. The court can have questions as a result of this hearing about what happened, but as the court knows, those questions are the province of the jury. It is for the jury to decide if it believes Mr. Mullis. It's for the jury to decide if it believes this other evidence, but this is all evidence that the jury should hear. Because Mr. Mullis is established, there is at least a reasonable likelihood that the outcome of this trial, overwhelming evidence that the court seen, that has read it and will read, that it's heard. This is evidence of an innocent man. This is evidence of a man that deserves a new trial, and a trial where he can have his day in court. And for that reason, Your Honor, we're asking the court to grant Mr. Mullis a new trial, and we'll provide additional legal briefing in the post-trial briefing that we make in a month, Your Honor. Thank you.
Thank you, counsel. I will await both parties' final briefing by the April date that we previously discussed. At that point, I will consider the matter finally submitted. Counsel, if you maybe just want to touch base with me briefly in chambers before you leave so that we can make sure that everybody is on the same page as far as the exhibits that were admitted. And then I'll give you a day or two just to review any final security level issues before I file the exhibit management order. Other than that, anything that we need to address before we go off the record? Anything on behalf of the applicant?
No, Your Honor.
Okay. Anything on behalf of the state?
No, Your Honor.
All right. Thank you all for appearing and for your cooperation to keep things moving throughout the trial these past days. Thank you.
Did they play the 911 call? I keep seeing it says that's like one of the number one reasons for that he could get a retrial. This says 4 days ago. Did we hear? I missed it, or I don't remember. I might have heard it, but I don't. You guys know how my brain doesn't work right. I don't remember it. Oh. Oh, I remember.
Pause it there for a moment. Mr. Hemingway, do you know whose voice you're hearing on this recording?
Yes.
Who is it?
Todd.
Mr. Mullis.
Yes.
Do you know who the other voices would be?
No, dispatcher.
A dispatcher.
Yes.
Okay. Okay, finish this one. That is the end of the first file. And so we will get the second file of 293 pulled up for you. Do you have an understanding of what was happening at the time of this, during this time period of the call?
Sounds like he's in his vehicle.
Do you know what kind of phone Mr. Mullis had?
LG flip phone.
For the younger people in the audience, what is a flip phone?
Oh yeah, I do remember this now.
It's a flip phone.
Does it folds together?
Yes.
I guess I did.
Does it have speakerphone?
Because I couldn't understand.
I believe so. I would assume. I don't know that for sure. I do not own a flip phone.
Okay. We will pick back up with the second file. Okay, so we are about 44 seconds into the second file. Did you hear Mr. Mullis say anything?
He's in a white Chevy. I don't remember any. I did. It's possible.
At that time, what's your understanding of what the dispatchers are telling Mr. Mullis to do?
I think they're instructing him to pull over, and they're going to start administering CPR.
Have you had other instances in Delaware County where people have driven themselves to the hospital?
I'm sure it's possible. Yes, I don't know of anything in particular.
And we can back it up. We'll back this up just one more time for you. If you could listen to see if you hear Todd ask anything else. Did you hear that? No? Okay. So we'll keep playing. Did you?
I can't understand what it says. Something about closer, maybe?
Okay.
I believe he's performing CPR.
Do you?
Would be my guess.
Do you?
Your Honor, can I briefly quadrille the witness for the purpose of an objection? Very briefly.
Go ahead.
Sheriff Hemeseth, were you on this 911 call?
No,
Were you with Mr. Mullis while this was occurring?
no.
Your Honor, I'm going to object that this is calling for speculation and
Okay. That I don't hear anything but just gobbledygook, garbled up mess. But oh, there's another trial that will be way into it by the time we get there if we're gonna do Karen Reed this week. We'll find something next week. Dang it. I should have left that other page up. Just looking at the thumbnails, all the people that did videos on this. Todd Mullis, complete 911 call and what he really says. I never even heard of some of these channels. Crime and Corruption, WTFF News. I've never heard of that channel. Oh, this is Court TV. Go to Hell, Cheating Whore. Todd Mullis caught on 911 call. Alleges. Wait. Oh. Go to Hell, Cheating Whore. Todd Mullis caught on 911 call. Alleges prosecutor on cross. So this must have been when he was on the stand. The prosecutor asked him if this is what he said or accused him of saying this on the 911 call. Oh, man. And this is a video, Mind Squash. I've never heard of this channel either. But it says that top reason for retrial 911 call and reasonable doubt. I don't see how that's a reason for a retrial. There's a 48 hours episode. Yeah, I'm going to have to listen to that 911 call on one of these other. The only thing is when you listen to them on, I know after we watch a trial, we get, we pick our side and we believe what we believe. And I don't disbelieve what YouTubers think, but once they make their mind up, they become biased. And like I said, I don't know whether he did it or not because I've not watched the first trial. But once you start listening to 911 tapes that they have enhanced or whatever to see, what did he really say, then you're going to hear it that way forever. It's like if you ever watch like a paranormal show, like a ghost hunting show or whatever, and they catch EVPs and then they're like, this is what it said. Like they'll play it once and you won't hear it. Or you'll hear something, but you don't know what it is. And then they'll say, this is what it said. And then when they play it again, then you hear it. And then you can't unhear it after that. You don't know if that's really what that said. You just hear it because you were told that's what it says. It might say that, it might not. You don't know. So that's why I almost hate to listen to it now instead of watching the trial first. But I don't have time to watch the trial unless I just stream it and we all watch it together. The trial was 5 years ago. The puncture wounds, 2 at an upward angle, 4 at a downward angle. Man, his mugshot. He looks so different. He's not a bad looking guy, but that mugshot, I don't know if it's the angle, if it's the distress from everything. He looks like a totally different person. But yeah, he has lost a lot of weight. Oh, that chapter did an episode on Todd Mullis. That chapter is a really good channel. If you haven't watched it, you should go check it out. Mike is the guy's name, and I think he's Irish. He has a really, really good channel. When I was first starting out, I'd binge watch his videos when I was trying to figure out how I was going to do mine, trying to figure out what my format of true crime videos is going to be. I would watch his a lot to get ideas. Okay. Oh, here's another one I haven't seen before. Lorden Arts. And her episode's called Case Cracked at the Red Shed. I still think they called it the Red Shed because red rhymes with shed. Because that's not a shed. That's a big building. Okay. Yeah, her testimony was interesting. The part, like I keep saying, the part about she moved, trying to get away from it, and the 2 prongs that weren't in that deep, and then she moved and they came out and then they went in another spot. That makes sense to me. But I don't know. If that's the only thing, I don't know. But okay, well, I will let y'all go. I need to cook dinner for my husband because he will be home soon. So I will see you guys in the morning for Phil Spector. And then I don't know what time the hearing starts tomorrow. I think I set it for 11 because the last hearing started at 11. But just make sure your bell is clicked for notifications because if it starts earlier than that, I will start when it starts. So I will see you guys in the morning. Bye. Have a nice evening, and I will see you around. I'll probably see some of you later. Bye.